Now let's hear from Julie Lowe, attorney at law. Julie, what's the difference between Medicaid and Medicare and who's eligible?
That's a great question. Medicare and Medicaid sound alike. They're almost the same word, so they're easily confused. Not only that, they're both government health programs that help pay for health care.
Okay.
They were both created in 1965, but that's where the similarities end. That's beyond that, they're completely different. So, for example, who runs the program is different. So the federal government runs the Medicare program. So there are consistent rules and regulations across the states, whereas Medicaid is a jointly funded state and federal program. And so every state has different rules for Medicaid.
I had no idea.
Yeah, so it's important if you're looking at Medicaid eligibility to be sure you're speaking to an attorney who's licensed in that particular state and knows that particular state's rules.
Okay. So could somebody in a case be eligible for both Medicaid and Medicare?
Oh, absolutely.
Oh, all right.
We refer to those as dual eligibles. And yeah. So another difference is how someone applies. Medicare, you apply when you apply for Social Security, and you're automatically eligible when you turn 65. And whereas Medicaid is applied through the state Medicaid agency, which in Massachusetts is Mass Health. Okay. So Mass Health equals Medicaid in Massachusetts. Another difference is what do they cover? So Medicare covers typical everyday services such as doctor visits, inpatient hospital stays. It also can cover prescription drug plans if you have a Part D plan. Whereas Medicaid is more focused on covering long-term care, be it in the community or within a nursing home.
Okay.
Either way. In addition, one program is needs-based and the other is not. Medicare, Bill Gates is eligible for Medicare. Okay, there's no income or eligibility requirement. Bill Gates would probably never be eligible for Medicaid because that is a program specifically based on need, and it's for individuals with lower income and resources.
Okay. So what is the role an elder law attorney plays in keeping somebody in their home as they age?
Well, an elder law attorney can play a very key role in keeping somebody home as they age. We are uniquely qualified in understanding the rules of the various community options that are available. For instance, in Massachusetts, there are 11 community programs that I can think of kind of right off the top of my head. Community Choices, Personal Care Attendant Program, Group Adult Foster Care, the PACE program, which you heard from earlier, fabulous program, Adult Foster Care, Enhanced Community Options Program. There are so many, each program has a different set of requirements and rules attached to it. So it can be difficult to navigate the rules of all those different programs. And quite honestly, when someone's facing this situation, they're facing it for the very first time. Whereas elder law attorneys and other professionals see these situations on a regular basis. So they can help you navigate the rules much better than you that are facing it for the first time. And so not only does an elder law attorney know the rules and regulations of the various programs, we also can help you legally reposition your assets to become eligible. Sometimes not even a lot of legal repositioning of your assets. So for instance, there is a home and community-based waiver program in Massachusetts that enables a client of mine to have a much higher income than is traditionally allowed under the Medicaid program. And with that community-based waiver, they can then become eligible for other programs like the PACE program, which is a fabulous program and is designed to keep people in their homes. The PACE goal and the client's goal are one and the same. PACE goes to great lengths to keep people in their homes. I've seen them buy hospital beds for clients. I've seen them provide machines for diabetic neuropathy and fingertips. I've seen them provide a great level of service to keep people in their home. And I think one of the things that we've learned is that the government saves money when it cares for people in the home. In fact, a recent study in Massachusetts stated that the government spends 35% less on an individual when they care for them in the community than in a nursing home. And so for those reasons, the programs they have a little bit less stringent requirements.
Okay.
Because the government laxed them up a little bit so that they could get more people eligible for home care to prevent that nursing home care.
Well, nursing home has become almost cost prohibitive for most people, correct?
Oh, absolutely. And so one thing that whenever you're working as an elder law attorney and your practice focuses on that, you come across numerous professionals that you learn to trust, and you can make referrals, and you can then work collaboratively with a number of resources to provide a holistic approach to someone's care, not only financially and legally, but also care management-wise as well. One last thing I want to say about home health care and how an elder law attorney can really help with that. I happen to be an accredited attorney with the Veterans Administration, and there is a great program, and it's a little-known program. I find so many veterans that know nothing about this particular program. It's often referred to as aid in attendance. But it's a great program that gives them a cash benefit monthly, tax-free, that enables someone to pay for care at their setting of choice. So for instance, a married veteran can be eligible for up to a maximum of $2,054 a month. A single veteran can be eligible for up to $1,732 per month.
Wow.
And a widow of a veteran can be eligible for up to $1,113 per month. The key here to the VA benefits is to understand how to qualify for those benefits. And it's also really key that if you do veterans benefit planning, that you also understand the interaction with the Medicaid eligibility rules. Because you can do veterans planning that actually renders you ineligible for Medicaid for the rest of your life. So I encourage any veteran who's seeking out elder law attorney services to make sure their attorney understands both the veterans benefits and the Medicaid rules and how they contradict and how they can work together so that they can always keep their eye on the other ball while planning for the better of the two benefits in any particular situation.
Wow, that's good to know. There's also another thing called an advance directive. What would that be?
So an advance directive is a legal document, sometimes often referred to as a living will.
Okay.
And so that talks about end-of-life care wishes. What kind of care do you want to receive? It basically provides instructions for the kind of care you want to receive. It's important to note that it's way more than a DNR.
Okay.
I hear clients say, well, I have a DNR, a do not resuscitate order. And an advance directive is much more than that. It can cover things such as additional medical procedures, artificial nutrition and hydration, and also it can be aimed at diagnostic procedures that are not aimed at curing the underlying condition. Many people don't want to go through diagnostic procedures that might be otherwise painful or uncomfortable when it's not aimed at curing the underlying condition towards the end of their lives. And sometimes when I think of the advance directive, if anyone remembers the Terry Schiavo case in Florida, advance directives and living wills became famous through that case.
Right.
So advance directive, think Terry Schiavo.
So what's the, you throw around a bunch of words here. So what's the difference between having a healthcare proxy and a medical power of attorney?
Oh, well, a healthcare proxy is considered a medical power of attorney. But there's also a durable power of attorney.
Okay.
So there are very big differences between a healthcare proxy and a power of attorney. The main difference is that a healthcare proxy in Massachusetts is designating an individual and alternates to make your healthcare decisions for you, whereas a power of attorney is designating an individual to handle your financial and administrative affairs in the event you, due to an illness or incapacity, you are unable to do those things yourself. So another major difference between the two documents is that a healthcare proxy is invoked if and only if a physician certifies that you're unable to make your own healthcare decisions.
Okay.
It's not effective immediately upon signing. Your healthcare decisions are not going to be, you're still making them. It's okay.
I think that's a very big fear among the elder community, is that they're giving power to somebody else.
Absolutely. And usually the power of attorney is effective immediately upon signing. You know, at least that's what I recommend to my clients.
Okay.
Why? Because this document is intended to prevent the need to go to court to get a conservatorship or a guardianship for an individual. Now, if you state in your power of attorney that, well, this is only effective when I'm incapacitated, and you take it to the bank, they're going to say, well, prove you're incapacitated. Well, then you're back in court.
Oh,
And you're spending tens of thousands of dollars in legal fees. Often, this is the document that's fairly inexpensive that everyone should have put in place. And it should be, if someone says to me, I don't really want to make it effective immediately, and I'll ask them, well, why? You don't. If it's because you don't trust that person, then we should be having a different discussion.
Okay.
That shouldn't be the person that you're naming in the first place. If you don't trust them now, you probably aren't going to trust them later either. So we usually
That's
have
a very good point. I like
we have
that.
a different discussion, you know, about that. And you know, I have to say that these documents are my pet peeves. Okay, the healthcare documents, which I refer to as a living will and a healthcare proxy and a HIPAA authorization, as well as the power of attorney, are documents that I think everyone over the age of 18 should have, but especially as you are aging and needing long-term care. It's crucial to have those documents in place while you still have the capacity to sign those documents.
Right.
Once you've gone too far and you don't understand what you're signing, we really can't do one. Okay, so it's really, really important. And more importantly, they need to have specific provisions, and they have to enumerate specific authorities and powers. For instance, I often see the healthcare proxy form from the hospitals. It's a one-page form that simply designates an individual. And if you don't have any other healthcare proxy and you're facing a medical procedure, you should absolutely sign that, because it's certainly better than not having one at all.
Right.
But you should go beyond that. You should list things. You should give someone instructions. Okay, you're asking someone to make some really important decisions, your healthcare decisions. You know, and they're difficult decisions because you're usually giving it to a loved one when they're emotional and maybe not thinking clearly. So I think you ought to give them some instructions and a little bit of guidance other than just naming them on a form. So, for example, you should express your intention to remain at home while giving your healthcare agent the authority to place you in a safe setting. You should also give your healthcare agent the ability to apply for government benefits on your behalf. There's things that should be specifically enumerated in these documents. You know, healthcare proxies are intended for real-life difficult situations. And when they have to be used, it's never easy. You want to make sure the person that you've designated understands your wishes. You can do so through the document. You should also have a conversation with those individuals. I think these documents are only as good as the conversations that people have around them. And when you really think about it, it's also, again, when a loved one is facing a really difficult time, perhaps, you know, the pulling of the plug decision oftentimes is a very difficult one, and a family member might have a lot of guilt around that. So having a discussion and giving them clear authority and stating your wishes about when and why you want that plug pulled is really important. It's really, the people I've talked to who've had to make those decisions were really glad that they had instructions.
Right, I can imagine.
Surrounding that. And likewise, the power of attorney document for financial affairs. You know, I see the standard form power of attorney. You can pull one down off the internet. This is another one of my pet peeves, because as you age, there are things that you should expressly authorize the person that you name to handle your financial and administrative affairs to do. For instance, you want to authorize them to do estate planning and or Medicaid planning. Okay, you want to give them the ability to gift your assets. You want to give them the ability to update beneficiary designations on life insurance policies and retirement plans. You want them to be able to handle your mail and your taxes. You want them to be able to take care of your pets. I mean, so in my power of attorney document, I expressly authorize very specific provisions, because the courts in Massachusetts have spoken, and what they have said is that if a power of attorney's actions come into question, and it was an action taken that wasn't specifically enumerated in the document, they lose every time.
Wow.
They've lost Medicaid decisions and appeals have turned on the power of attorney document. So it's not just simply a pet peeve.
Right.
In real life and in a difficult situation when an action's being challenged, it's really important to give express authorization for very specific things. So that general statement in a power of attorney that they can do whatever I can do,
Right.
I think is insufficient. Necessary, but also to add to its specific powers.
Wow.
It should be in there.
Incredible.
Mine has a table of contents, if that gives you any idea. So,
Well, it sounds very comprehensive and good both for the person it's protecting and the person who has to make the decisions, it sounds like.
and that's who I'm writing it for.
Yeah.
I'm not writing it for the institution who has to read it.
We talked earlier about long-term care insurance, something that is a relatively new product in the marketplace, probably last 5-10 years. You hear more about it lately, but I think it's become more and more of a need for most people.
Oh, yeah, absolutely. And so long-term care insurance, first of all, if you want to purchase long-term care insurance, you should definitely seek out an insurance professional that's uniquely qualified and knowledgeable about this particular insurance product. It's unlike other insurance products. So what does it cover? Long-term care insurance is designed to cover custodial long-term care services, those services required due to chronic illnesses or a condition that's lasting a prolonged period of time. If you remember from the earlier discussion we had about Medicare versus Medicaid, Medicare does not cover long-term care services. No one should rely on Medicare for long-term care services. That would be a mistake. So long-term care insurance can fill the gap and provide custodial care when it's required or when skilled nursing care is required beyond what Medicare will cover.
Now, but is there a situation where you could be on Medicaid and also have long-term care?
Yeah, absolutely.
Okay.
Oh, absolutely. I have a client right now who's receiving veterans benefits and using his long-term care insurance policy to finance a stay in a fairly expensive yet very nice memory care unit at a local assisted living facility. You know, the costs there are running between $9,500 and $10,000 a month.
Wow.
There's very few people, and that's for a memory care unit in assisted living. So it's pretty high-end care, and he needs the highest level of physical care as well as the memory care. So, you know, so it's very expensive, and very few people have the means to pay for that kind of care on any kind of long-term basis. And so there's three basic types of long-term care policies. There's nursing home only that may also cover assisted living facilities as well. There's home health care only policies, and then there's comprehensive policies that will cover the whole range of services from home care through assisted living and all the way into nursing home. The typical policy is structured normally as a daily benefit rate.
Okay.
It'll say, oh, we have a maximum daily benefit rate of $125 for particular service. Okay, maybe higher for a nursing home and lower for a home care. They may say you get 80% of the benefit for home care. And then it's also usually given a maximum benefit period. So if you have a 2-year policy that provides 2 years of care, that would be 730 days of care.
Okay.
And then they would times that by the daily benefit rate to come up with your maximum benefit. So you can have a policy that, for instance, covers $125 a day for 730 days over the course of your lifetime.
Okay.
Okay. Now, another important thing about, and I heard it mentioned earlier, is the elimination period. There are little nuances around that in a policy, and you should read it carefully. The elimination period can differ from policy to policy and can make a huge difference in when the benefits kick in, how they kick in, and are they maintained, or do you have breaks in coverage and then have to start a new elimination period? Is it a lifetime elimination period? There are things like that that should be looked at. And so there's also, within Medicaid, there's a special rule and regulation.
Of course, there's a special rule.
There always is a special rule or the exception, right? And so long-term care insurance, if you purchase a particular type of policy that meets certain minimum requirements, you can actually be exempt from Medicaid estate recovery and liens, which is the process by which, if you are on Medicaid during your lifetime, the state of Massachusetts will attempt to recover against your estate after your lifetime.
Okay.
And that's done through the probate process, and there are ways to avoid that, but other ways to avoid that, but one way is to have the right kind of long-term care insurance policy. If you buy a policy, though, for this particular reason, you should have it reviewed by an elder law attorney or someone else who really knows exactly how the rule is
To make
played
sure
out.
if you're looking for that coverage, you're getting it.
And played out in real life. I mean, there was an interpretation of the policy until recently the legislature updated it because it was being interpreted in a strange way and not in the benefit of the client or patient. And really, it was a measure by our legislature to encourage people to buy these policies to reduce their dependence upon state and federal benefits. And so that's what it should do. And and there was an interesting information I came across. The National Association of Insurance Commissioners actually established some suitability rules for long-term care insurance. In the Northeast, or anywhere actually, they recommend that no more than 7% of your income should be spent on long-term care insurance. Bottom line is, if you're purchasing long-term care insurance, it should not change your lifestyle significantly to pay the premiums.
Right.
Okay? And one last thing is, if you buy a policy, before you sign on the dotted line, it might be a good idea to have an elder law attorney review it, because they may see some nuances in those policies that you may not notice or even realize the consequences of it. Even if you understand what it's saying, it may be hard to imagine the consequences as you're signing that policy of what that sentence really will mean to you down the road.
Well, and I can imagine, too, that not only does the long-term care insurance provide some peace of mind that you can pay for the care that you need when you need it, but it also is protecting your assets as well, for if you want to bequeath them to somebody later on.
Oh,
Correct?
absolutely.
Yeah.
Absolutely,
It's
yeah.
kind of a double-edged.
Yeah.
That's great. Wow. Lot to consider.
There is a lot to consider.
Well, thank you for joining us today.
Well, thank you very much for having me. I appreciate the opportunity.